In this session, we're going to cover contracts. Contracts is a very important topic, especially for business. And contracts, as we'll go through, we're going to cover a lot of material, but um, is again a course that takes up an entire semester in law school. And so we're covering a lot of material over the course of this thing, but it's important material, especially for business. So a contract, everybody should know what a contract is, but just a basic definition is a contract is an enforceable agreement to do something. An example is one person may agree to paint someone's house. Uh, that person agrees to paint the house in exchange for a payment of money. Uh, that would be, it may be a written agreement, it could be an oral agreement, but that could be an agreement that could be construed to be a contract. And that's in the basic sense of you've got two parties agreeing to perform something. One is going to paint the house, one is going to pay the person for painting the house. If the agreement is broken, if the person uh, doesn't paint the house, they may have a claim against them. Vice versa. If the person paints the house and the person won't pay them for painting the house, the person that painted the house would have legal rights against the person who is refusing to pay. So contracts arise in our everyday life, and the same is true for business. Contracts are going to be in a part of business, whether you're in the healthcare field or you're in sales or you're in manufacturing, whatever industry you're in, contracts are going to be part of that business. So some examples that you may see in business, you have agreements in which you're going to sell products, or maybe an agreement in which you're providing a service. Uh, Contracts come down to the simple basic operation. You have a contract to rent space, or you may have contracts to rent equipment to use in your business. Similarly, you could have a contract to hire workers. So you may have an employment agreement. You may hire uh, certain employees pursuant to certain terms for the work. You also have contracts through insurance. You contract through insurance for things such as workers' compensation. That's a contract. You get insurance to cover commercial general liability. That is a contract. So contracts come about in business on a very regular basis. So before any legal rights rise, we took the example of the person who was going to paint the house in exchange for payment. So there has to be a valid contract before there's any legal obligations or any legal rights in which they would be entitled to recourse for a breach. Without a valid enforceable contract, there's nothing you can do. Maybe you were talking about an agreement for them to paint the house for a price, but you never formally uh, met all the requirements to have an enforceable contract. If that is the case, if it was just a matter of discussion and some negotiations, but no formal contract was reached, then if the person doesn't paint, uh, then there's no harm because you had no legal obligation for them to paint the house. Similarly, because they didn't paint the house, they're not entitled to the money. So, under this notion, you have to have a valid enforceable contract, and that's a good starting point for us to discuss. And we're going to spend a good chunk of the material tonight talking about the four requirements that are required for a valid enforceable contract. So, the first requirement is that there must be a meeting of the minds. And this is shown through having an offer and then an acceptance of that offer. And so when we use the term meeting of the minds, that's the term that the courts have developed. It basically means that you have an understanding as to what the subject matter is and what the terms are. And so everybody is on the same page, so to speak. So the parties have sat down and they've come to an understanding the meeting of the minds and have come to an agreement, and that is what results in a contract. But that's the first requirement, is there has to be a meeting of the minds. And that is usually typically shown through an offer and acceptance. You have to have where someone offered something and then that the person accepted the offer. The next requirement is there has to be consideration. Consideration is the legal name for value. There's got to be some value tied to it. Doesn't have to be a large value necessarily, but there has to be some exchange of value tied to it. Then the third requirement is the parties have to have the ability to contract. As we'll learn in a little bit, there are certain people, for example, minors or people who are mentally incompetent, who lack the capacity to have the meeting of the minds. By law, minors and mentally incapacitated people do not have the legal capacity to have a meeting of the minds, to appreciate what they're agreeing to and to understand it. And without that capacity, they can't execute an enforceable, valid contract. And the last requirement is that the contract must have a legal purpose. It is against the contractual principles to be able to contract for an illegal purpose. So it's a contract that's illegal is void. So let's begin with the meeting of the minds. We have the offer. As defined by the book, and this is a good definition of it, an offer is a manifestation of willingness to enter into a bargain that justifies another person in understanding that his or her assent will conclude the bargain. So you have, let's take the example that we started talking about earlier. The offer in the painting of the house may be a homeowner tells the painter, if you will repaint the interior of my house, I will pay you $2,000. That would be an offer because the homeowner has expressed a willingness to enter into a bargain, and it's one that should that justifies the painter in understanding and believing that his agreement to those terms will conclude the bargain, will create a meeting of the minds. And so we have the technical terms that are used. The offeror is the person who makes the offer. The offeree is the person receiving the offer. In the example that we've been doing, the homeowner is the person who made the offer. The offeree, in turn, is the person receiving the offer, and that is the painter. So an offer, there's no strict requirement that it has to be in writing. It could be in writing, but it doesn't have to be. You could have an oral offer. Very common for probably the painter and homeowner to not execute a formal written agreement. It would be very common for their offer and acceptance to be oral. You could also have a contract or an offer that's implied by the conduct. And so in that example, you could have an offer in writing, oral, or it can be implied in the conduct. An offer is binding if these three things are present. The offeror, the person making the offer, so in our example, the homeowner has to intend to be bound, the terms have to be reasonably definite, and the offer has to be communicated to the offeree. So in this scenario, the painter. So the intention. So the offer's intention, you determine that based on the outward acts rather than unexpressed acts. So it's hard to know if the homeowner intended to be bound based on some subjective thoughts or beliefs that he had. So you can't judge whether he intended to be bound by his offer of painting the house for $2,000. You can't judge that based on his subjective beliefs that are unexpressed. Rather, the only way that you can judge his intention to be bound is what his outward acts are. In this instance, he's told the person that I will pay you $2,000 if you paint the inside of my house. His outward acts that he's done would express an intention to be bound. So, talking about the subjective doesn't apply, so it's the judged by an objective standard. You take things that are offers that could be seen as a joke to not be true. They're not genuine offers, and so an example here is I will sell you my car for $30. No one's going to sell their car for $30. That would not be taken as being a intention to be bound. Whoever says that it doesn't have any intent of being bound to sell their car for $30. That is based on an objective standard. The reasonable person would not sell their car for $30. And then on offers, you got to think about advertisements. In business, there's a lot of advertising. You've got to advertise to get people to come to your store, to buy your product, to eat at your restaurant, whatever it may be. But advertisements are treated as negotiations rather than an offer. So an advertisement, we're not too far away from Thanksgiving. You have Black Friday coming up. Everybody probably gets out and shops, but on that Thanksgiving morning, people go out, they buy a paper, they open it up, they look at all the advertisements for all the sales at Target, Walmart, the shopping places at the mall, the Macy's, the whatever. You look and you see what are their advertisements for the Black Friday sale. Well, that would not be an offer. You can't bind Macy's to be able to sell you a shirt for $20. That is normally $60. And that's an offer for you to come in and negotiate or look for it. It's not an offer in which you can have a meeting of the minds. So the other requirement is that there has to be some definiteness to the terms of the agreement. So when you are having the meeting of the minds, you can't have the meeting, and you can't have a true meeting of the minds sufficient to bind you to a contract if you haven't discussed the essential terms. So what are essential terms? Well, it's the subject matter of the contract. So in our example with the painter and the homeowner, in that example, if there may be subject matter, but what if they didn't talk about the price? If the homeowner said, I will pay you to paint the inside of the house, and that is probably missing an essential term, and it may not be accepted as being a true offer because the term of price is missing. If that's missing, then there's most likely no contract. So we talk about offer, and the question arises is once you make an offer, are you bound by it forever? Is it permanent? The answer is no. The offeror, the person making the offer, can terminate an offer or the offer may expire by law. So in our example, if the homeowner tells the painter, I'll pay you $2,000 to paint the house, and before there's a response from the painter, if he decides, no, I don't want to paint my house, he can go back and rescind that offer. He can go and tell the painter, I'm sorry, I'm not gonna paint my house now. I'm not asking you to do that anymore. So he can rescind it, take back that, and the painter, once it's rescinded, can no longer accept the offer. Termination by law, this is where if you set a time period within which you have to make a decision, then by operation of contractual principles, that offer is no longer valid. So if an offer is extended to buy something for 2 weeks at a reduced price, and the 2 weeks pass, and then the day after the 2 weeks end, a person sends in a purchase order, that would not be a valid acceptance because the offer has extinguished by the operation of law. Another way that you may have the law revoke an offer is if the offeror dies or becomes incapacitated, because if they're dead or incapacitated, there cannot be a meeting of the minds or to bind them. So, so as long as the offeree has not accepted the offer, as long as the offer is still just an offer, then the offeror has the authority to revoke his offer. An offer was also considered to be terminated if the offeree makes a counteroffer. So in the example that we've used so far, if the homeowner offered $2,000 to paint it and the painter responded back at I will paint the house for $2,500, then the offeror's offer for $2,000 has been rejected, and the $2,500 is a counteroffer. And so at that point, the offer can no longer be accepted at $2,000. So there are two scenarios here where an offer may not be revoked. So we just talked about that an offer can be revoked as long as the offeree hasn't accepted it. Well, there are two instances in which, two circumstances that could alter that rule. One is an options contract, and an option contract is one in which the offeror agrees to extend the offer for a set period of time in exchange for some consideration. So, say, take purchasing a home, for example. Someone may come in and say, we want to buy this home, but we've got to sell our home, and they could come in and offer them, say, $2,000 to give them an exclusive right for 30 days. Well, if they take that $2,000, they have to give them 30 days within which they could purchase the home. And so you could have an options contract in that sense. You could also have the example of where the offeree has relied upon the offer to his or her detriment. So an example may be with our painter, if he's not formally accepted the offer to paint the home for $2,000, but he's gone out and he's hired people to come work, and he's bought a ladder, and he's bought paintbrushes, and he's bought paint, and then the offerer or the homeowner wants to revoke the offer. Well, the painter has relied on the offer to his detriment. He's changed his position because he's bought all the paint he needs, the paintbrushes, hired people, bought a ladder, and so he's expended money in reliance on the offer. In that scenario, the offeror, the homeowner, may not be able to revoke the offer to paint the home for $2,000. So here's a detrimental reliance. We just went over that. I guess I jumped the gun, but when they relied upon the offer, you can't revoke it. So the delta of this is the doctrine of promissory estoppel. When you detrimentally relied, promissory estoppel may apply, and it estops you, or it prevents you as the offeror from being able to revoke your offer. So it's an equitable based doctrine. And so in the painter scenario, promissory estoppel would stop the homeowner from being able to revoke the offer to paint the home for $2,000 because he relied on it, buying supplies, hiring workers, things like that. So let's talk about acceptance. So if you've got a valid offer, how can you accept it? So acceptance is a response by the offeree, the person to whom the offer was made. So in our scenario that we've used, the painter. So it's a response by the painter that indicates that they agree or they assent to the terms of the offer. So an acceptance can take a lot of different forms. It's just like with an offer. It can be in writing, it can be orally, or it can be implied by conduct. the conduct. Take the example of the painter that we've been talking about. The painter may go buy all the materials and he may show up with the paint and all this stuff, or that implies that he's accepted the offer. So he may have not said, hey, homeowner, I formally accept, but he may call him and say, what colors do you need? I'm at the paint store and I'm going to pick up the paint and I'll be at your house tomorrow to paint. That conduct indicates that there's been an acceptance of the offer. So the offeror is considered the master of the offer, and so in that vein, the offeror can specify exactly the method or manner in which the offeree must accept. So it's very possible that, go back to our example, the homeowner, when they make the offer of, we'll pay you $2,000 to paint the inside of the house, they may say, you've got to send us an answer by email by a certain date. They can specify exactly how they want it to be done. They could also say, we want you to call us and let us know. A lot of times they may not specify anything, and so then anything that could be construed as an acceptance by conduct, or it could be a written acceptance, it could just be a phone call, it could be a text message. Any method of that would work to create a meeting of the minds because you've had acceptance. But if the offeror does specify exactly how the offer is to be accepted, then the offeree has to follow that. If the offeree fails to follow the required method, then there will be no valid acceptance. So if they say you've got to email us, and they give you an email address, and you send them a text message, that's not going to be valid acceptance based on the offer. So the mailbox rule is kind of antiquated, but it's still, people do still use the mail, just not as much as they used to. So, but the mailbox rule is the rule in which acceptance is effective once you place the notice in the mailbox. Once you put your letter in the mailbox, it's effective. So if you put it in the mailbox, the offeror can't come back and revoke, even though they may have not received it yet. Once it's postmarked in the mail, then it's considered a valid acceptance, and the offeror would be precluded from revoking. So in our example, if the homeowner specified that you've got to send me a written notice by mail, and the painter goes and he mails his letter on February 16th, that's the day, February 16th would be the day in which acceptance is valid. So if on February 18th, before receiving it, the offeror calls and says, painter, I am rescinding the offer. I've decided that we don't want to paint the house at this time. The offeror can no longer revoke the offer because the contract has been formed at the time of mailing. The mirror image rule. This is a common law doctrine that requires in the concept of contracts that the offeree must accept the exact offer that's made by the offeror. So if the offeror, back to our example, says, I'll pay you $2,000 to paint the house, then the offeree has to accept the offer of $2,000 to paint the house. The offeree can't come back and accept at a higher price or change other terms. The offer accepted has to mirror the offer made. If the terms are not identical, then the mirror image rule provides that there is no contract. Instead, the additional response would be considered a proposal or a counteroffer. So you would not have a valid contract. Now, in the concept of sales, as we talk about this in this week as well, it is drastically different how it's treated, because there is, in fact, under the UCC, no mirror image rule. But we will cover that in more depth in the sales chapter. So acceptance, again, just like you have with the offer, there's an intent to be bound. So you've got to both the offer and the acceptance has to have an intent to be bound. That goes right back to the meeting of the minds. You've both got to be on the same page and have an intention to be bound by the essential terms of the agreement. So when there is this intention to be bound to these essential terms by both the offeror and the offeree, then a contract is formed. Even if there are some minor details that still need to be negotiated at a later date, there would be a binding contract as to the essential terms. So that's the first requirement, the meeting of the minds, the offer, the acceptance. Now let's look at consideration. Like I said, consideration requires the offeree and the offeror to provide something of value. Let's go back to our example that we've done. What's the value that's being provided? Well, by the homeowner, they're paying $2,000. That's their value that they're contributing. That's their consideration. Well, what about the painter? What's his consideration? He's not putting any money up. Well, he's performing a service, and his promise to paint the house and his performance of that is the consideration. So his promise to paint the house serves as his consideration. The money that's being provided in exchange for that promise and work is what the homeowner is putting up as his consideration. So consideration can take many forms. It doesn't have to be money, but money, the service, the promise, or even forbearance of a right, abstaining from doing something, forbearing some legal right could constitute consideration. So here we have the example. We've already gone over the one, but it's another one. If the buyer provides money and the seller provides a car, so in the sell and buy of a car, the car serves as consideration and the money serves as consideration. So we'll talk about a promise could qualify as consideration. Well, if it's an illegal promise, it is not sufficient to serve as consideration for a contract. So there's no bright line rule on exactly how much consideration is needed. The book uses the term of a peppercorn. That's a famous, comes from a famous case in which we studied in law school that, peppercorn, meaning it doesn't have to be a very significant amount of value, but you just have to have some value to make it meaningful. So we talk about promises. A promise to perform a pre-existing duty or obligation that you already have isn't consideration because you're not really giving up any value because you're already required to do that. You're going to do it regardless of whatever contract is being made. So the consideration has to be adequate, which again goes back to the peppercorn. There's not an exact bright line rule of consideration has to be at least $100 or anything like that. It's a case by case determination, and there just has to be some value. And if the consideration is considered to be lack genuineness or the point that you don't find that it has value, like a sham, then the consideration is going to be inadequate. So consideration, a lot of times what you find is it's a promise to do something or the performance of the act itself, and so the service. Those come up quite often. Money is often involved, but those are probably service, money, and a promise are the biggest things that constitute consideration in most contracts. So bilateral contract is a mutual exchange of promises. Both parties promise to perform an act. So let's go use the example that we've been using of the homeowner and the painter. That's a mutual exchange of promises. One promises to pay $5,000 to the painter, the homeowner does, if he will paint the home, and the homeowner promises to paint the home. So you have both of them making promises. Example here, Susie promises to pay Tim $5 to rake his yard and 10 promises to rake Susie's yard. That's a bilateral contract in which both parties have promised to perform an act. In contrast, a unilateral contract is a promise in exchange for a performance of an act. So Susie promises to pay $5 if he rakes her yard. So there's not any exchange until he performs the act. You've got to consider illusory promise. This is a promise that provides no benefit to the person who would receive the promise, nor does it subject the person making the promise to any detriment. So essentially, an illusory promise is one in which there's no consideration because you're either bound or you're not bound. You don't have any real promise in it. So the example here is Ted agrees to buy firewood from Bill when he needs it. Well, there's no binding agreement because Ted may not need to buy any firewood. So if Ted promises to buy firewood when he needs it, is there really a promise? What has he really given up? Nothing. If he ever needs firewood, he will buy it from Ted, but he may not ever need firewood. Under consideration, the book talks about requirements contracts and output contracts. Requirement contract is an agreement to buy required commodities from a seller, but it's where you don't know the exact quantity. So you agree to buy everything that you need to buy from this person. You just don't know what the quantity is. Well, you don't lack an essential term in that scenario or consideration because the buyer is bound to buy whatever's needed from the seller. So you'll have a binding agreement even though there may be a question of consideration because you don't have a firm commitment of what one is doing. They're not promising to buy 500 gallons of oil. Instead, whether they need 500 or they need 100 or they need 1,000, they're going to buy it from you, and so there's a binding agreement. So an output contract is similar, but it's one in which a buyer agrees to purchase all of the output that the seller produces. Again, the exact amount is unknown, but the buyer and seller agree to be bound to each buy and sell. Another principle that comes up under consideration is conditional promises. A conditional promise is an agreement that's conditioned upon some certain event, whether it's one that must happen or not happen. But before an event must either happen before, after, or during. And so an agreement is conditioned upon the event, and it will be binding if the event is beyond the person's control. So you have condition precedent. The event must occur before a party must perform the contract. This is one in which performance isn't required until this condition is satisfied. So the example here is ABC Corp is a book publisher. It's interested in purchasing Book Co. Book Co is both a publishing and a distribution company. ABC Corp doesn't do distribution, they do publishing. So they don't want the distribution operation of Book Co. ABC Corp therefore executes agreement with Book Pro, a book distributing company, in which Book Pro agrees to purchase Book Co.'s distribution business if ABC Corp buys Book Co. So in this example, Book Pro is not obligated to buy Book Co.'s distribution business until ABC Corp buys Book Co. So if ABC Corp never buys Book Co., then Book Pro is never obligated to buy the distribution business. So the purchase of Book Co. by ABC is a condition precedent to Book Pro's agreement to buy the distribution business. A condition concurrent, it's where a condition in which the parties are required to perform simultaneously. So, let's do the easy example of ABC Corp has to pay for the car it buys from Ted's Motor Company, and Ted's Motor Company has to provide the vehicle. These are both conditions that are being performed at the same time. The condition subsequent is just like you would expect. It's a condition that occurs usually, and it will terminate the contractual obligations. So let's take the example we've used for the condition precedent, but let's assume that BookPro agrees to purchase BookCo's distribution unless BookCo's valuation is valued at less than 500 million or 5 million during the audit. So here they're going to purchase BookCo, and they're bound by that unless the valuation's not there. So if they're obligated to do it, but if a condition occurs, which is the low valuation, then BookPro is not bound to purchase them. Then the contractual obligation is terminated. So in the condition precedent, the happening of the condition in that example, it sprung to life, the right to, brought to right the requirement to perform or to act. In this scenario, a condition subsequent is extinguishing the contractual obligation, the right for them to have to purchase BookCo. Promissory estoppel, we talked briefly about that, but it ties in, so we'll talk about it quickly. You've got generally all contracts have to be supported by a consideration. Promissory estoppel is an exception to this requirement. And so promissory estoppel, it requires that an injured party establish three things. It's just not because some party doesn't want to perform and you feel like you've relied upon them, it's not automatically promissory estoppel. You've got to show these three things. You got to show that there was a promise that was justifiably relied upon. So you've got to show that, let's go back to our example that we talked about with promissory estoppel, where the buyer, or excuse me, the homeowner made the offer. The painter went out and bought the paint, bought the ladder, the paintbrushes, hired workers to come. He was justifiably relying upon that promise from the homeowner. So the reliance was foreseeable. It's foreseeable that if you tell someone to I'll pay you this to paint the home, it's foreseeable that they'll paint the home for the money. And injustice would result if the court didn't provide relief to the injured party. So in this scenario, there would be injustice, arguably, because the painter has relied upon it and gone out of pocket and bought a few $100s worth of paint, and he's bought $100 worth of paintbrushes and rags and a ladder, and has committed to pay his workers. And so he spended a quarter or more of what he would be getting paid already in preparation for doing the job. So in that scenario, promissory estoppel would probably apply, and it would prevent the homeowner from revoking the offer. Or even if it was a contract and they were breaking the contract, it may stop them from breaching the contract. Here's an example. We've just gone over one, but you can see it. It's there. For the sake of time, I'll move on. So capacity. This is the third requirement that's needed in order to have a valid and binding contract. So we talked briefly on capacity, about how it requires that you have the mental ability to understand the terms and conditions of the agreement. Without the mental ability to understand the terms and conditions of the agreement, there can't be a meeting of the minds. So generally the law says that minors and those that are deemed to be mentally incompetent, they lack the mental ability to execute valid contracts. They lack the capacity to have a meeting of the minds. And so because element 3 is not met, element 1 in turn is not met. So contracts that are executed by a minor or someone that's mentally incompetent are usually voidable at that person's election. And saying that it's voidable, that means that the person may cancel the contract or they may choose to enforce the contract. The contract is not invalid as a matter of law. The contract may be enforced if the minor so chooses. So the person, the minor has the option. So if, let's go back to the scenario we have. If the homeowner contracts with the painter and they have an agreement, but the painter is actually 17 and the age of majority, which is typically 18, so we'll take 18 for that. Since he's under 18, his contract will be voidable. That means he has the option to either enforce it and paint and get paid the $2,000, or he has the right to cancel that agreement and walk away without being in breach or subject to any contractual legal liability to the homeowner. But the flip side is not true. Just because he's 17, the homeowner doesn't get to cancel the contract themselves. It's up to the painter's decision. So the homeowner can't say, oh, I now learned you're 17, I'm canceling the contract. So an example about it, or an exception about this though, is the minor, if our painter lied about his age, then he may not be able to cancel the contract. So if the homeowner said, you look really young, are you really 18? Are you really old enough to do this? And the painter says, oh yes, I'm 22. I've been painting for years, but I'm 22. Then in that instance, they lied about their age and they most likely would not be able to void the contract if they decided. So looking at mental incompetency, the courts will often declare people to be mentally incompetent. They may have a conservatorship or they may have a guardian for them. If a court deems you mentally incompetent and there's a guardian or a conservator, then the contract is void and has no legal effect. The law has already, through the court has already declared you to be incompetent, so there's no question about whether you had capacity and there could be a true meeting of the minds. In that instance, the contract cannot be enforced. But if there's no declaration from a court hasn't made a decision about your mental competency, then the contract would be voidable if the person did not understand the terms and conditions of the agreement. So if the person is mentally incompetent and doesn't understand the terms and conditions, then it's voidable, which is the exact same thing like the example we just did with the minor, meaning that if the painter is, instead of being a minor, is mentally incompetent, but if he understood the terms and conditions of the agreement, if he did not understand the terms and conditions of the agreement, then it would be a voidable contract. The painter would have the option to say, I'm walking away from it and not suffer any legal liability. Or alternatively, he could decide, I'm enforcing the contract, I'm going to paint the house, you're going to owe me $2,000. In that scenario, he could elect if he wanted to enforce it or not. But in the instance of there is no declaration by court, then the contract would be enforceable if the painter understood the terms and conditions of the agreement, even though he may be mentally incompetent for other things. If he understood the simple terms of you paint the house, we'll give you $2,000 for painting it, then there's a meeting of the minds, and they had capacity to make this contract, make this agreement, even though he may be mentally incompetent for other things such as making medical decisions. So ratification is a possibility. So if you have a minor person or a mentally incompetent person, once they achieve capacity, so in the example that we did for the minor painter, at 17, if when he turned 18, if he was just a couple weeks from turning 18, once he turned 18, he could ratify the voidable contract. If you ratify it, then the contract is valid and enforceable. You would no longer have that option of it being a voidable contract at the painter's election. So let's look now at the last requirement to have a valid legal binding contract. The last requirement is that the contract must be for a legal purpose. Contracts that are contrary to law, contrary to public policy, to a statute, all of those are going to be deemed illegal and unenforceable. So this element is actually pretty easy to meet. Most contracts that people are looking to make are not illegal. You know, it's not often that someone's out contracting with somebody to say commit some criminal act. You know, if they're contracting with somebody to commit a criminal act, obviously that's against the statute because whatever act they're being asked to perform has been criminalized as being against public policy and against the social norms of our society. And since it's against a statute and criminalized behavior, it would be an illegal act. And so you cannot have a valid binding contract to force somebody to engage in, say, criminal activity. But most contracts are valid, are enforceable, and legal. It's not very common that you have where somebody's trying to contract for an illegal purpose. But some of the examples that could come up is usury statutes, and these are the ones where they set a maximum amount of interest that may be charged on a loan. And so you could have, it's possible that you could have somebody that writes loans in all 50 states and they have high interest rates and they messed up and the statute's been changed and they've got their standard form and they could charge interest rate that's higher than the maximum allowed by the usury statute. So if the usury statute set at 20% and they charge 22% in their interest documents, then that cap is illegal and it would not be an enforceable contract.